Now, I should be very thankful of newly promoted additional public prosecutors who have taken the efforts for you all in order to arrange this speech. And particularly, I would like to thank firstly Mr. C.Y. Patil, secondly Sri Datrange, Maithili Kalvint, Veena Gajbee from Nagpur, and Mr. Singada also, who was ex-assistant director and public prosecutor to our cadre. Now he is retired. Now we have to decided to discuss and have a practical aspect instead of delivering the lecture to the subject of how to conduct the sessions trials with a special reference to the provisions of the Evidence Act. So I am very proud that tomorrow you are going to conduct the sessions trials in the sessions court. I am of the opinion that you should conduct the trials in such a manner and such a fashion by studying the law regarding the sessions trials and especially with the provisions of the Evidence Act. You should be treated that every additional public prosecutor in the entire state of Maharashtra is dealing with the sessions trials in a very good manner, and because of your efforts, the rate of merited conviction will be increased in the entire state of Maharashtra. So you are required to fulfill this requirement, and for that purpose, very hard study and efforts are required to be taken. What type of efforts are required? What type of study is also required? I am aware that you are studying during course of you conducting the trials in the magistrate's court, but now you are conducting the trials in the sessions court, wherein a different mode of a procedure and the application of the Indian Evidence Act is required. मी आपल्याला यामध्ये मराठीतून असं सांगेन की आपल्यावर या ठिकाणी सेशन्स कोर्टामध्ये सेशन्स केसेस चालवण्याची जबाबदारी शासनाने टाकलेली आहे. ती जबाबदारी तुम्ही अतिशय चांगल्या रीतीने प्रत्येक केसचा आणि त्या संदर्भातल्या कायद्याचा अभ्यास करून ही जबाबदारी पार पाडायची आहे. मी असं स्पष्टपणे म्हणेल की ज्यांना यामध्ये एफर्ट्स घ्यायचे नाहीत, ज्यांना ही चांगल्या रीतीने जबाबदारी पार पाडायची नाही, त्यांनी स्वतःहून ह्या केडर मधून सोडून जावं. परंतु एखाद्याने कुणीतरी काही याप्रमाणे केस नीट चालवली नाही तर त्याकरता सबंध केडर बदनाम होता कामा नये. आणि म्हणून आतापर्यंत एवढ्या प्रकारचा अभ्यास करावा लागत नव्हता. आता तुम्हाला सुरुवातीची 2-3 वर्ष पुन्हा तुमचा अभ्यास आपोआप होणार आहे, परंतु सुरुवातीची 2-3 वर्ष तुम्हाला यामध्ये खूप मेहनत, खूप वाचन, खूप स्टडी, खूप चर्चा या पद्धतीने या प्रकारचं असलेलं सगळं ज्ञान तुम्ही मिळवायचं आहे. तेव्हा मी एवढं स्पष्ट बोललो याबद्दल राग मानू नका, परंतु आपल्यावर एवढी जबाबदारी टाकलेली आहे. तुमची जबाबदारी त्या ठिकाणी काय आहे की व्हिक्टिमला न्याय मिळवून देण्याची. तेव्हा अशा रीतीने व्हिक्टिमला न्याय मिळवून देण्यामध्ये जर तुम्ही त्या ठिकाणी कमी पडलात, इट अमाउंट्स टू कॉजिंग इनजस्टिस टू द व्हिक्टिम. तेव्हा तुमची जबाबदारी व्हिक्टिमच्या बद्दल आहे, शासनाच्या बद्दल आहे, केडरच्या बद्दल आहे आणि कोर्टाच्या बद्दल आहे. अशा 4 लोकांच्या बद्दलच्या तुम्ही जबाबदाऱ्या पार पाडायच्या आहेत. यामध्ये कोणत्याही प्रकारचा हलगर्जीपणा हायगय अजिबात करू नका. अशा रीतीने सेशन्स केस चालवा. याचा अर्थ मी असं म्हणत नाही की प्रत्येक सेशन्स केस मध्ये शिक्षाच व्हावी. तुम्हाला मेरिटवर केस चालवायची आहे, तेव्हा सर्व प्रकारचे प्रयत्न आपण अतिशय भरपूर वेळ देऊन आणि मन लावून सुरुवातीचे 2-3 वर्ष अभ्यास केल्यानंतर आणि केसेस चालवल्यानंतर तुम्ही त्यात सीझन्ड व्हाल. आणि कित्येकदा काय असतं की अमुक एक प्रॉसिक्युटर म्हणल्यानंतर डिफेन्स काउन्सिल सुद्धा घाबरतो. तसा तुमचा वचक निर्माण झाला पाहिजे. असा वचक हा कशाचा? तुमच्या ज्ञानाचा, तुमच्या अभ्यासाचा, तुम्ही घेतलेल्या एफर्ट्सचा असा एवढा वचक निर्माण झाला पाहिजे. आणि विक्टिमलाही वाटलं पाहिजे, विक्टिम जिवंत असेल तर त्यांनाही वाटलं पाहिजे की आपल्याला या प्रॉसिक्युटरकडून न्याय मिळेल. आणि या सर्व जबाबदाऱ्या तुम्ही कोर्टाशी चांगल्या प्रकारे वागून, कोर्टासमोर लिनियंटली वागून या सर्व जबाबदाऱ्या पार पाडायच्या आहेत. मी जो सब्जेक्ट निवडलाय तो हाऊ टू कंडक्ट सेशन्स ट्रायल इन द सेशन्स कोर्ट with special reference to the Evidence Act. How to apply the provisions of the Evidence Act. I am aware that during course of the conducting the trials before the magistrates court, that much application of the provisions of the Evidence Act was not required. But now, every now and then, the provisions of the Evidence Act are required to be applied, and you are required to adduce the evidence accordingly. Now, केडरला कोणत्याही प्रकारे केडरचं नाव कमी होईल असं वर्तन नको. असं अभ्यास कमी केला तर एखाद्या केसमध्ये तुम्ही जर व्यवस्थित अभ्यास केला नाही त्याचा अर्थ काय होतो? रिमेंबर, द विक्टिम इज युअर क्लायंट. The state government is your client, and if you are negligent regarding the preparation of that particular case, you are causing injustice to your own client, that is the victim, as well as the state government, which should not happen. Now, you are aware regarding the subject, and after completion of this subject, we will take another subject, that is how to conduct the criminal appeals and the criminal revisions in the sessions court. That will be a lecture of only one lecture, that is enough. But for this subject, that is the how to conduct the sessions trials with special reference to Evidence Act, 4-5 lectures are required, because we are required to go into the details of in every provision. For that purpose, I am requesting you all to purchase at least bare acts of Criminal Procedure Code, Indian Penal Code, and the Evidence Act. Now, remember, mere reading of the provisions of law is not enough. If we, instead of reading it, if we will write the provisions of the Evidence Act and other laws, that is the best effort in order to remember that provisions of law. I am giving my own example. When I was a junior advocate, I wrote down the Evidence Act, provisions of Evidence Act for 7 times. And thereafter, I was giving the book in the hand of other advocate, and I used to read the provisions of the entire Evidence Act. Because तुम्ही ज्या क्षेत्रात काम करताय त्या क्षेत्रामध्ये तुम्ही तज्ञ असलं पाहिजे. एखादा डॉक्टर तज्ञ नसेल आणि कॅन्सरचं ऑपरेशन करीत असेल, हार्टचं ऑपरेशन करीत असेल, तर परिणाम काय होईल? तो पेशंट मरेल. असाच परिणाम आपल्या हातून देखील घडण्याची शक्यता आहे की जर याप्रमाणे आपण चांगल्या प्रकारे अभ्यास केला नाही आणि चांगल्या प्रमाणे सेशन्स ट्रायल चालवली नाही तर सेशन्स ट्रायल चालवण्याकरता आता आपण यापूर्वी वॉरंट ट्रायल चालवलेले आहेत. वॉरंट ट्रायल आणि सेशन्स ट्रायल यामध्ये फारसा फरक नाही. तथापि या ठिकाणी रिस्पॉन्सिबिलिटी ही लार्जर अमाउंटवर येते. म्हणजे काय की तुम्ही प्रॉसिक्युटर मॅजिस्ट्रेट कोर्टात काम करत असताना मी पाहिलेलं आहे की संपूर्ण केसचा अभ्यास करीत होता किंवा नव्हता हे माहित नाही. परंतु आता तुम्हाला संपूर्ण सेशन्स केसचा अभ्यास कशा रीतीने करायचा आहे त्याबद्दलच्या प्रोव्हिजन्स आता आपण पाहणार आहोत. आणि म्हणून बिफोर गोइंग टू द provisions of the Evidence Act and application thereof, I am dealing with the procedure law regarding conducting the sessions trial. What procedure is required to be adopted before you proceed to lead evidence? For that purpose, remember there is a provision in the Criminal Procedure Code which has been given in section 226 of Criminal Procedure Code. What is 226? That is the opening case by the prosecution. What is that? I have observed as a director of prosecution. I have observed as a defense counsel also earlier to that. And I have observed as a session judge that nobody is opening the case under 226. Why? Because in order to open the case under section 226 of the Criminal Procedure Code, the study of the case is required. If you are not studied the case properly, if you are unaware of the facts of that particular case and what is the evidence collected by the investigating officer, then you are unable to open the case under section 226 of the Criminal Procedure Code. So, what is to be, how to open the case, I will come to later on. But before that, how to study the case is very important, and for that, I am giving you one tabular form, which you will not find this tabular form in any books or somebody who followed such type of tabular form in the entire state of Maharashtra. If you adopt that procedure of that tabular form, your entire case will be at a glance on one single paper before you. For that purpose, you are aware that whenever it is a sessions trial, the case has been committed by the magistrate to the sessions court. When case comes to the before the court, what you are required to take the steps till the recording of evidence. That steps are very important. In order to go through and follow those steps, you are required to study thoroughly the entire case. And in order to prepare to that effect, you are required to, I am giving you the tabular form. If you are having papers with you, you may take down it or write down it on horizontal size of the paper. Horizontal size, not vertical side, because there are 14 columns. And if you write all those columns, the entire prosecution case will be on your one paper, at a glance. That will be useful to you every now and then, as well as at the time of the arguments also. So, if you take down this pro forma, that will be very useful to narrate the entire case, and the distance, the evidence at a very simple or a minor evidence you can place before the court or submit before the court at the time of opening of the case. How it is to open, I will come to the later on. Before that, I will dictate those 14 columns wherein the entire case you are required to study and fill in those columns, so you will get the entire picture of your sessions case. For that purpose, I will slowly dictate. Take column number 1 as a serial number. Then column number 2, name of the witness. Column number 3, examining on what point. Then 4th column, statement regarding incident. That means what that witness has stated before the police when his statement was recorded under section 161 Crpc. So column number 4 is a statement regarding the incident only. Do not write other things. I am residing there, I am having so much family members and others. Don't write. Come to the aspect of only the point of incident. Then 5th column, injuries described. So those injuries not as per the medical expert or medical certificate or according to the postmortem report. No. Injuries mentioned by that witness in his statement. Then 6th column. 6th column is a weapon used. What he is describing regarding the use of weapon. That means what weapon was used by what accused. So narration of that weapon of assault used by the accused during course of the incident. Then 7th column is sometimes apart from weapon, other articles are also mentioned. So what are those other articles? Other articles referred by the witness. Then 8th column, the description of the clothes of the victim. The description of the clothes on the person of the victim you will get in the Panchanama, perhaps later on. But if the clothes on the person of the victim are disclosed by any of the witness while recording his statement under section 161 CRPC, as per that description, then description, then 9th column, a description of the clothes on person of accused. Sometimes that may be absent also, but whenever it is described that such and such documents were on person of the accused, so this description of the clothes on person of the accused, if described by the witness, you are required to mention here. Then column number 10th, blood group of the victim. For this purpose, you are required to take the help of the CA report, Forensic Science Laboratory report regarding the blood group. Then 11th column, blood group of accused. For this purpose also, you are required to take the help of the CA report. Then 12th column, injuries as per medical certificate of injured and injuries as per post-mortem report of the deceased. So 12th is as per injuries as per post-mortem or certificate, because injuries are already, it has come in column number 5, that is the described by the witness. Now 13th column is a CA report. What is CA report? Regarding the clothes, regarding, on which cloth, which blood group was noticed, on which weapon of assault, what blood group was detected. So this was required to be mentioned in this column. On the contrary, I am of the opinion that regarding the blood group of the complainant, if alive, injured or deceased, that glove you should have a list of that. Then blood group of the accused, the blood group found on the person, on the clothes of the victim or the accused, the blood group found on the articles, that is the weapon of assault, etc. And the last column, 14th column, that you are required to mention here, which injury is possible by what weapon. Because when you are examining the medical officer, you must ask the question to the medical officer that this is the sword before the court, and this is the post-mortem report. Whether the injuries mentioned in the post-mortem report, column number 17, are possible by the weapon article A, sword before the court. So you are required to ask that question. And this type of pro forma is required to be maintained by every prosecutor before opening the case. Now, another chart is also required. This is the one chart. The another chart, you are aware that now CDR reports are available. That is the telephonic calls from one mobile number to another mobile number or landlines. And the nodal officer is issuing the certificate to that effect. And copy of the said is required to be delivered to the accused also. Because of this telephonic message or connection inter se, you are required to connect or show before the court that at such and such time, the accused has made a telephonic or mobile call to the victim or somebody else. That is also a very important evidence nowadays, which shows not only calling inter se, but the location of both mobile numbers is given. And whenever that report comes, relying upon that report, you prepare a separate chart. So that may be called phone call details. For that purpose, there are 8 columns I have prepared. The first column is phone number of the accused. What is phone number of accused? Then second column, contacted phone numbers. Which phone number was contacted by the accused? Then third column, to whom it belongs. That contacted number, to whom it belongs. Whether it belongs to the victim, whether it belongs to any witness. Because you are aware that phone number of accused as column number 1. To whom it belongs, you are required to write the name and his status, whether victim or the injured or any other witness. Then fourth column is time of call. At what time call was made? Then fifth column, the duration of call. How long talk was going on? And the sixth column is the location. Location of the other call to whom accused has made calls. Or if somebody has made call, witness has made call to the accused, you may take another same thing regarding the location. Where is the location of accused? You will find out the location of the accused as well as all other persons who had inter-talk between them, either on the landline or on the mobile phone. Then seventh column, statement of witness regarding calls. So what he has stated during course of his statement recorded under section 161 CRPC. What is his story regarding the calls? Whether he has made call, whether other person has made call, regarding that statement of the witness. What is his statement? And if there is conversation, if any, if conversation is there, you may mention what is the conversation, if any. So these 2 charts are required to be prepared by you. What is required for preparation of these 2 charts? The thorough study of the entire case is required. I have come across that one prosecutor in the city civil court was conducting the murder trial without papers. I immediately withdrew his assignment. So what he was doing? He was totally negligent and conducting sessions trial like murder trial without papers before him. It should not happen. So you should prepare these 2 charts. I would like to give the name of these charts. You may have discussion inter se. These are the 14 columns, 14 column chart, whether you have prepared 14 column chart. Or in Marathi, you may ask 14 column chart, 14 column chart तयार केला का? And if you are preparing that, that means you have studied the case. I have come across several prosecutors that without studying the case, they are conducting the trials in the magistrate courts. Also, I have come across, I have personally noted visiting that particular courts. So it should not happen. More responsibility on your shoulder now. If you want to continue, I have initially told you, you are not ready to take the efforts, leave the cadre. So आपण याला नाव द्यायचं 14 कॉलम चार्ट. If you have prepared, then you come to the court under section 226 of Criminal Procedure Court for opening of the case. Why case is required? What is the meaning of the opening of the case? Opening of the case doesn't mean you are required to adduce the evidence. You are required to call the witnesses. No. You are required to submit before the court what is the prosecution case and what is the evidence in short. Why such type of opening is required? On going through your submissions during course of opening of case under section 226, the court has to make up his mind regarding the next section, that is next two sections, that is 227 and 228, that is either to discharge the accused or frame the charge against the accused. So, relying upon your submission, I am of the opinion that you should discuss at the time of the framing of the charge, and you assist the honorable judge at the time of framing of the charge. Remember always, the charge is required to be fixed. Charge is required to be framed under section 228. But prior to that, there is a provision under section 227 of which is called a discharge of the accused. Accused can be discharged when there are no sufficient grounds to proceed against him. You have studied it. So if there are no grounds to proceed against him, accused can be discharged. Likewise, in warrant trial, likewise, in the sessions trial also, if there are no grounds to proceed against the accused can be discharged. There are several cases wherein accused has been discharged under section 227. Now, the defense counsels are filing application under section 227 for discharge. In my opinion, there is no provision to file such type of applications because section 227 and 228 are to be considered by the court simultaneously at the same time. If court, without any application filed by the accused, comes to the conclusion that there is no grounds to proceed against the accused, the court will discharge the accused even though the defense counsel has not filed any type of application for discharge. So, what is your now responsibility? To assist the judge for the framing of the charge or the discharge. Remember that. You are not subordinate of the investigating agencies. So you should not adopt that whatever investigation agencies has stated. You may point out before the court also, because you want a merited conviction and not a pressurized conviction. So, at the time of submitting the court under 226, 226, 227 and 228 can be read together. And that procedure of these three sections can be adopted at same and one time. Even a defense counsel also take the part at the time of the framing of the charge also. So how the charge is to be framed? You are required to assist the honorable court. If any charge is missing, you may point out at the same time, honorable court, the charge under this section is required, but it is not framed. So the prosecution is requesting to frame the such type of charge. If it is not done, you may file application also. If you are not satisfied with the charge, because I have come across that prosecutor is filing such type of application. I am not aware of that, why they are not filing. No court fee label is required for the filing application before the court. Even then, no such type of applications are taken. Efforts are not taken to file such type of applications. So now you are required to assist the court for the framing of the charge while opening the case under section 226. So what is to be argued? Your Honor, this is the prosecution case in short. This is the evidence in short. And so charge is required to be framed under these sections of the Indian Penal Code or other laws. If court is of the opinion that the charge is required to be framed and this is not the case of the discharge. So if accused is not discharged under section 227, your task started. If the accused is discharged under 227, your work is over. But after framing charge, your work starts. Now, for framing charge, what is required? The facts of the case are also required. Apart from that, what other things are required for framing of the charge? And all those steps are required to be completed by the prosecutor. What are those steps are required to be taken? The step that you should not proceed with the case unless and until all articles are brought before the court. Sometimes it happens that after committal, the CA reports are obtained by the police. But if CA reports are not called, do not open the case. Because it is up to you to open the case under section 226. So, if what I was saying, if CA report is not filed, call IO or write a letter to IO, or if the IO is transferred, write a letter to the senior police inspector of the concerned police station, or calling of CA reports. He will go to the forensic science laboratory and collect the reports and file in the court. Because if CA report, you are conducting the sessions trial without CA report, that will be another ground for the defense for adjournment. Because they will say, unless and until I have CA report, I cannot take the concrete defense. It is also CA report is also necessary for the prosecution to prove its case. Therefore, two things. If the articles are not before the court, if CA reports are not before the court, call those articles, call those CA reports, give the copies of the CA reports to the accused, that is by the court, and after receipt of this, you are required to open the case. Now, another aspect. Before opening case, sometimes it happens that one of the accused is not appearing before the court and he is absent. The prosecutor is required to take the steps against him. If one of the accused is absconding, file application. It is, don't think that it is the job of the court only. It is the duty of the prosecutor to point out that this accused is not remaining present and he is not represented by any of the advocate. And if he has been released on bail, request the court by filing application to issue warrant against him. And simultaneously, not only warrant, simultaneously notice to a surety under section 446 of the Criminal Procedure Code that why surety should not be forfeited. So, two prayers are required in that application. And accordingly, after passing order by the Honorable Court, the warrant will be issued. After issuing such type of warrant, if accused is not traced and report has been filed by the IO or the police commissionary that his whereabouts are not known and he was not found, in that event, it is necessary to file an application by the prosecutor before the court under section 82, subclass 2 of the Criminal Procedure Code for issuing proclamation against him. In the said application, you may have two prayers that proclamation be issued against him, and before filing that application, you may call IO or the police machinery and ask him to bring the 7th extract of the accused, bring the house record of that particular accused, so that you may attach that to your application and request the court for attachment of the said movable or immovable property. If movable property, you are required to give the list, and list is to be called from the police machinery. The 7th extract and other record of the ownership record, titles record is to be called from the police machinery. And you are required to submit along with your application that the accused is absconding, his warrant was issued against him, his whereabouts are not known, he was not traced out at the time of particular execution of the warrant. Therefore, issue proclamation against him and simultaneously attach the property either movable or immovable. If he doesn't have any immovable property, you have no alternative but to attach the movable property only, giving the description of the movable articles found in the house of the accused. So these things are required to be done. So after proclamation has been issued, 1 month is required to be waited. And if it is serious case like murder, you are requested to file application before the court for issuing declaration under section 82 subclause 4. So declaration is required to be issued in serious cases. Proclamation is also required. And after expiry of the time, if the accused does not appear, in that event, the case is required to be split up against that accused. For that splitting of the case, that is the section 317, and apply for request the court for separating the trial. Separate his trial, split up the case, and on your request, the court will split up the case, and trial will be commenced against the accused who are present before the court. At that time, framing of the charge is very important also. In framing charge, what wording is required? That you accused number 1 to 4, along with absconding accused so and so. This wording is very necessary in the charge. And after passing the order by the Honorable Court, the trial will be split up and separated. And again, if trial has been separated, the charge is required to be framed. So charge will be framed under section 228 of Criminal Procedure Code. Now remember, regarding charge, you are aware that charge is framed under section 220 of the Criminal Procedure Code. However, how to frame charge? For that purpose, section 211, 212, 213 are required to be taken into consideration while framing the charge. In that three sections, 211, 212, and 213, section 213 is very important, because section 213 says in the charge what is to be mentioned, the manner of conducting the offense is required to be narrated. That is section 213. So merely saying that you have committed his murder, no. You have committed murder by the means of the sword, by administering the poison. This type of manner of weapon of assault or manner of commission of the murder, commission of the offense is required to be mentioned as per section 213. So now charge is framed. Charge, after framing the charge, it is the duty of the court. You should be silent. It is to be explained to the court, explained to the accused in his own language. And it is required to be mentioned that charge was read over and explained to the accused in his language. If he is a foreigner, if he doesn't know Marathi, If he knows Hindi, then in Hindi, in English. So, medium of the narration is required to be mentioned. Then and then only he will understand the charges against him. Why these provisions? If you will go through the entire criminal procedure code, the majority of the provisions are regarding in favor of the accused. The safeguarding the provisions. So, accused must know what charges are leveled against him, what charges he has to face, and that is why the manner of commission of the offense is required to be mentioned under section 213 while framing of the charge. Now, the charge is framed. His plea has been recorded. If he pleads guilty, then what is to be done? Till now, you were doing, or you are aware that if he pleads guilty, he was convicted immediately by passing the order by the court. Likewise, there is also provision in the Sessions Trial, section 229. On pleading guilty, he has to be convicted. But remember, in cases of serious offenses, 229 need not be followed. Court need not pass the sentence or order of sentence, because it is the duty of the prosecution to prove the case beyond reasonable doubt. If prosecution fails to prove the case beyond reasonable doubt, there is no alternative but to acquit the accused. Therefore, in serious cases, the accused cannot be convicted under section 229. Therefore, in majority of the cases, 99% cases, 229 is not followed and observed by any of the courts, even though there is a provision. And therefore, after section 229, another section comes, that is section 230. Date for prosecution evidence is to be fixed by the court. But before that, before fixing the date for the prosecution evidence, on the date of the framing of charge, you may request the court that I am giving the list of the documents under section 294 of Criminal Procedure Code to admit or deny by the defense. That list would have been ready. Court may not grant adjournment for that purpose. So that list should be ready on the date of the framing of the charge itself. It is not obligatory on the court to adjourn the matter for your filing the application under section 294, report under section 294. So 294 provision is, why it is a provision? Because you are required to give the list of the documents and say the accused or defense is called to admit or deny the documents. You are required to give the separate copy of that list to defense. And if defense is ready on the very day to file a reply regarding admission or denial of the documents, then there is no question of adjournment. But if defense seeks adjournment, it is between the honorable court and the defense. Prosecution has no role. So you are required to give the list. For that list, there is also a proforma. The list should be given in the proforma, and that proforma
क्रिमिनल मॅन्युअल मध्ये दिले सर.
Yes, it is in the criminal manual. I have noted that I am not getting just now where is that, but it is given in the criminal manual 294, where I have mentioned 294. Yes, 294(1), application for admission of the CA reports and other documents. CA report and other documents. All documents. Even Panchanamas also. Even requisition letter issued to several officers, that is the forensic science laboratory, medical officer, or other, even for the Tahsildar for preparation of the map of the place of incident. So all these requisition letters, every document, other than the statements of the witnesses. You may also add FIR also in that. It may or may not admit. It is also a document. So you are required to give such type of list. So that list is, what I will do? Yes, that list format is given in chapter 6. Chapter 6 of the criminal manual, para 32. Chapter 6, para 32, and there are seven columns. Remember always, whenever you are filing any application before the court, you should note the provision of law. Application on behalf of prosecution under so and such provision. Without provision, filing application that includes, it indicates that you are unaware of that provision of law, and that is why you are not mentioning the provision of law. Every application must be on the provision must be mentioned, because without provision there is no provision of the filing of such an application also. So after filing application under section 294, the defense will admit or deny any of the documents. If defense denies all the documents, nothing is required to be submitted before the court. If defense admits some of the documents, at that time orally you may request the honorable court that defense has admitted such and such documents, and those documents be exhibited, because exhibition of those documents means what? What is the evidential value of those documents? The admission of the documents by the accused under section 294 is only the formal proof. Remember, every document has two aspects. One is the execution of the document, and second is the contents of the document. Whenever you want to prove the document before the court, two things are required to be proved by you. One, if it is a FIR, ask the complainant that whether this is your signature. If he admits, the execution of the document is proved. So what is the meaning of execution of the document? That is, signing of the document amounts to execution of the document. What about the contents? So in order to prove the give the exhibit to FIR or prove the document, two things are required. Whether this is your signature. Then next question, which is very important, that whether the contents of these documents are correct. If he says yes, then you request the court to give the exhibit. Now here under section 294, the contents are not proved. Only execution is proved because it is a formal proof. For example, if defense has given admission for I admit the postmortem report, that does not mean that you should not examine the medical officer. You must examine the medical officer. For that purpose, what other things you are going to gain? Through the examination of medical officer, you are going to prove the contents of that postmortem report. Another aspect, you will show the weapon of assault before the court to the medical officer, and showing that weapon of assault, you may ask the medical officer that whether such and such type of injury mentioned in column number 17 is possible by this weapon. So even though prosecution has admitted any minor document, that is the requisition letter, they are not challenging it. You may give exhibits. Even you may not examine witness on that point, and straightway request the court, after giving the consent by the defense, it should be your request that those documents, exhibits be given. And accordingly, court is required to give such type of exhibits to all those documents. So this stage is complete now, section 294 CRPC. For example, in some of the cases, there is expert evidence, handwriting expert evidence. You are required to call the handwriting expert's evidence. Even though his evidence is not binding on the court, still you are required. Why? Because the procedure adopted by handwriting expert for coming to the conclusion is required to be narrated before the court. If he is not expert, his opinion cannot be taken into consideration. You are aware there are provisions in the Evidence Act accordingly. So, even though the opinion given by the medical handwriting expert is not binding on the court, you are required to examine in order to mention or narrate the procedure, depending on which procedure he depended and came to the conclusion that this is the signature of the deceased. How? What procedure he adopted? So you are required to examine such type of witnesses even though there is a formal proof. So you decide yourself even though they have admitted which witnesses to be called. So now section 294 CRPC is complete. Now next stage, that is section 230, that is the day for the prosecution evidence. That is the next date. Whenever there is a day for prosecution evidence, that means there is earlier to that, there is another stage. The prosecutor is required to give the list of witnesses for the purpose of issuing the witness summons. I have already, when I was the director of prosecution, I have already issued a circular to that effect. Because I come across that the prosecutor is giving the list of the witnesses as per the charge sheet. No. If any witness says or he's in his statement that I came to know regarding the incident, I heard regarding the incident, that witness is hearsay evidence, inadmissible in evidence. Do not call such type of witnesses. Therefore, your list of witnesses should be in such a manner that which witness you give the name of the witness, examining on what point. To that effect, list of witnesses is required to be given. If you are giving the list of witnesses as per the charge sheet, you can be held as a negligent, because you have not gone through the case. You would have gone through the case, prepared the chart, opened the case under section 226. Certainly you will prepare the list as per stating the role of that particular witness. Don't call the witnesses unnecessarily. Remember always, Supreme Court has held that the witness is the guest of the court. He is coming before the court to assist the administration of justice, avoiding his daily work, every work, and attending the court. Do not send him back. Examine him on very day. For that purpose, you are required to take one step, that give the list before the court, how many witnesses today are present before the court. That list is required to be given. How court will come to the that how many witnesses are present? Don't submit orally. Give the list, how many witnesses are present before the court. And it is the duty of the court also to examine all the witnesses without sending back. Don't send witness back, because he is the guest of the court. Further, I am saying that he is the guest of the court, but honored guest of the prosecution. So you must take care that he is paid. Meager amount is paid as a bhakta. You are asking them wait for 2 hours, 3 hours for bhakta. They are attending the court at 11 and you are asking in the evening that no, your matter has been adjourned and come on another day. No, don't do that. For this purpose, I would like to quote one judgment of the Supreme Court. That judgment is AIR 2001, Supreme Court, page 1403. AIR 2001, Supreme Court, page 1403, wherein the direction has been issued by the Supreme Court for every judicial officer. Don't send any witness back without examination. and the direction has been issued by the Supreme Court to the High Court that take legal action against those judicial officers who are sending witnesses back without examination. That is the ruling under section 309 of Indian Criminal Procedure Code. That is regarding the adjournments. So now you are issuing the such type of giving the list for issuing the witness summons. Witness summonses are issued, and for that purpose you arrange the examination of those witnesses in such a fashion that don't call all the witnesses on one day. Divide the days depending upon the strength and the strength of the witnesses. Don't call all the witnesses on very day. It is merely harassment to the witnesses. So, when he is honored guest of the prosecution, that honor is not given to him. Till today, I have observed that nobody has given such type of list before the court that such and such witnesses are present. Why not given? Whether court is not accepting it. So it makes a record that so many witnesses were present and they were not examined and they were sent back without examination. Witnesses are honored guests. I visited several talukas. I found, you are aware that your department has been separated from the police machinery by standard judgment by the Supreme Court. But still you are observing the same procedure regarding the attendance of the police in your office. I observed. The chairs are kept in your office for the sitting purpose of the witnesses. Those chairs are occupied by the police. Why? Ask them to wait outside. So, the chairs which are for the witnesses, they are standing. And you are refreshing the memory. So, don't do this. Henceforth also. Don't give your chair to the police machinery. If the witnesses are not there, in that event it is all right. But witnesses present, they are standing. And the police machinery, 3-4 police occupying the chairs. Why it has been separated? Do you want to go back again? That cannot happen. Even all assistant director and public prosecutor should issue the circular to that effect to the talukas. This happens particularly to talukas. You are saying that witness is the honored guest. Supreme Court says he is the guest. So, in this ruling just now, I have mentioned, same thing I have mentioned. Don't send witness back without examination. This is the order of the Supreme Court. You are required to follow. So, I am asking you a simple question. There are several cases regarding the race of the bullock cart. Several persons are offense has been registered against them. There is no law to prohibit such type of the race of the bullock cart. If the offense has been committed and the case comes before you, under what provision you are going to convict him? Because there is no provision in the law, any law. But Honorable Supreme Court has issued the direction and prohibited to such type of bullock race. So whenever there is a direction from the superior court or the officer, And if it is not obeyed, still it is offense under section 188. Read the contents of wording of that section 188. But I come across two cases of the bullock race. In that, section 188 was not applied. In that event, what is the duty of the prosecutor then? You request the court to apply section 188. Some other sections are applied. So when there is no provision to bar the such type of bullock race, still it is an offense under section 188. You are not observed the order of the Supreme Court, Apex Court. So, calling of the witnesses. Witnesses should be called in and arranged in such a manner that no witness shall be sent back without examination. Sometimes what happens, in several districts I have observed that the case-wise cases are distributed to the additional public prosecutors, and he has to deal that particular case wherever it may be. That should not happen. When I was the Director of Prosecution, there were meetings before Honorable Chief Justice, wherein the Director of Prosecution, the Director of Forensic Science, and Director General of the Police were the members of the said meeting, wherein Honorable Chief Justice directed me that one prosecutor, one court. Otherwise, what happens? If there are 4 partnered cases in one court, the case of A prosecutor, case of B prosecutor, case of C prosecutor, case of D prosecutor, all 4 prosecutors are in one court and other 3 courts are vacant. That is why Chief Justice directed me. I have issued the circular to that effect and I started this procedure in Bombay particularly. Don't give the cases. Appoint the prosecutor case-wise. He should be court-wise. He should conduct all the cases in the said court. I am giving this example why? Because if 4 matters are partnered before one court and witnesses have come from the 4 cases, how you will examine all the witnesses in all the cases? This should not happen. And therefore, every prosecutor should be to a particular court and not case-wise. Now, regarding the witnesses, witnesses are called before the court. They are summoned, they are present, and defense counsel are requesting the adjournment. Follow the procedure given under section 309 of Criminal Procedure Court. It says, when the evidence has been opened and the defense is requesting for adjournment, no adjournment shall be given. After opening the case by examining the witnesses, there should be a day-to-day trial. In old days, when we were also the session judges, we were keeping the case after opening the case every day. But nowadays, date is given 15 days, 1 month. What is this going on? What is the meaning of sessions? What the because section 309 says it should be next day on certain conditions. That is the word used in section 309. Sufficient, not only sufficient reason, special reason. under Order 17 Civil Procedure Code, in civil matters, sufficient reason is required for adjournment. But Section 309 for criminal matters, a special reason is required. So what is special reason? Defense counsel busy in another court is not a ground for adjournment. In such matters, what is to be done by the prosecutor? If they are on the bail, request them to take into the custody. File application. That is what it is mentioned in section that ruling. You read that ruling carefully. Everything you will get there. So there should not be adjournment except next date, next day, not date, next day. And for reasons to be recorded, it should be recorded. Whether you have gone through that, the reasons are recorded. Even though adjournment has matter has been adjourned for several days. So you should request that it should be kept day to day. So that is the, now I am requesting one another aspect. Before that, that you should read, not only read, write Evidence Act. Every day you write 20 sections of that Evidence Act. This is the book of Evidence Act. How big is it? How big is it? How much time is required to write the provisions so that you will understand it better? So you write at least 20 sections every day, and on completion of it, go on writing again. I told I wrote it 7 times. Still I remember the definitions of this. Every day, now and then we are saying this is the fact. But what is the definition of fact? Nobody knows. I will say. Fact means and includes anything, state of things, relation of things, capable of being perceived by the senses, any mental condition of which any person is conscious. This is the definition of the fact. You are saying the prosecution has proved the case. What is the meaning of the proved? What is the definition of the proved? Mere saying, using the word proved. I am telling you, don't use the word which word you heard somewhere. Unless and until you have read it, do not use that word before the court. So, you are using the word case has been proved. What is the definition of proved? I will tell you. A fact is said to be proved when, after matters coming before the court either believes it to exist or considers its existence so probable that a prudent man ought, under the circumstances of a particular case, to act upon that it exists. This is the definition. What is the definition of the disproved? A fact is said to be disproved when, after coming the matters before it, the court either believes it does not exist or considers its not existence so probable that a prudent man ought, under the circumstances of a particular case, to act upon that it does not exist. So what is to be, how to conduct the cases? How much law you should read? If you read after reading, you will realize that how I was unaware of those provisions of law, and now I am satisfied that those provisions of law I am well acquainted now. So this is for 2-3 years you should take. After 2-3 years, you will be very well acquainted with all the procedure as well as the Evidence Act. This is applicable for each and every moment and each and every case. Because for your proof, you are required to rely upon the Evidence Act. And therefore, for Evidence Act, may I take 5 minutes break?
Yes.
Just 5 minutes
Yes,
to
sir.
have water.
Yes. 5-minute break.
ते नको पाणीच प्यायचं आहे. होय ठीक चाललंय. नाही असं नाही म्हणजे काय म्हणजे now we are on the point of recording of evidence. Before recording that evidence, if all accused are present, the question does not arise. But if some of the accused are absent, you are required to follow the procedure just now I narrated regarding the issuing of the warrant, proclamation and declaration. And thereafter case is to be separated. If the case has been separated, then what is to be done? Whether separate record is to be prepared for that split up case for regarding the absconding accused, or same record is to be mentioned in that case also. Whether the separate case number, session case number is required to be given to that split up case? No. The only there is order of split up case. The copies of this document cannot require to be taken away and separately maintain the record and proceeding. No. Same record and proceeding. But another responsibility, procedural responsibility. If the proclamation has been issued and the accused does not appear and the case has been separated against him, then what steps are required to be taken by the prosecutor regarding the absconding accused? So you are today, complainant is present and you want to examine them. Before you proceed to record the oral evidence, you should request the court to pass an order regarding the evidence now recorded will be also read against the absconding accused if he will be traced out and arrested later on. That is section 299. You are all aware that there was one subject for your workshop also, section 299 CRPC. That is the recording of evidence in absence of the accused. So what is the procedure exactly to be followed here? Because there are two cases wherein the section 299 is applied. One is the case wherein the accused is unknown and the case is before the magistrate. In that event, magistrate has to record the evidence in absence of the accused. Said case cannot be committed because there is no accused. Accused is either one absconding or either wanted accused. Accused was not traced out. Why section 299 has been implemented in the Criminal Procedure Code? Because if the case is started and some of the accused are absconding, and after some years they are traced out, and meanwhile any complainant dies or important witnesses are no more, or they have gone abroad or not available for the cross-examination, in that event, the examination in chief of this witness is required to be read against the accused in absence of cross-examination. This is the provision under section 299. But how it will be applied? After some years, he was traced out, he was brought before the court. The earlier case has been already disposed of. They were convicted. And thereafter, he was traced out and he was brought before the court. In that event, what is to be done? It is required to be requested to the court to pass an order. Unless and until such type of order is passed, the evidence recorded cannot be read against that absconding accused when he was traced out. What order is required to be passed? That one warrant was issued against the accused, he was not traced out. Proclamation was issued or declaration has been issued, he was not traced out. His surety bond has been already forfeited, and therefore his case has been split up. There are no chances of tracing out the accused in a near future. Therefore, the evidence in this case will be read against the absconding accused. This order is required. If such type of order is not passed, the evidence already taken cannot be read that against the absconding accused after his tracing out, unless and until such type of order is passed. For this purpose, I am giving you quoting one judgment. That judgment is 1975 Criminal Law Journal, page 285. The name of the parties is very difficult to pronounce. I will just give you a spelling. GAVISIDDIAH versus State of Karnataka, wherein it is mentioned that unless and until such type of order is passed, you should have this ruling with you, because you are going to face trouble at this stage, because you are required to convince the court on the basis of this ruling cited, that such type of order is required to be passed, and unless and until such type of order is passed, that evidence cannot be read against the absconding accused when he was apprehended subsequently. So this is regarding the absconding accused, the evidence. So that order is required in that case itself, and thereafter, if accused is brought before the court and witness is not traceable, or died after 10 or 15 years, then that evidence without his cross-examination is admissible against that accused, and follow this procedure. Otherwise, what happens? That absconding accused, the stage of absconding is beneficial to him. If there is no evidence against him, he will be acquitted. Perhaps he will be discharged under section 227. Therefore, now there is no question of discharging 227 because the evidence is sufficient before him. But that evidence, if you are recording the evidence after his tracing out, and if any witness dies or not found, that evidence will not go against him, which is beneficial to that accused, and he should not get that advantage of his own act of absconding. It is his own act. So, because of such type of procedure, everybody will abscond, and they will appear before the court after 20 years. Where are the witnesses? They are not present. So, if witness is alive and present before the court, no doubt he has a right of cross-examination. Therefore, you are also required to take the mode under section 299 of the Criminal Procedure Code. Now, the entire evidence has been recorded. How to record evidence, we will come to the later on. Of which witness, particular witness. How to examine the medical officer who has issued the postmortem report, etc. बस करायचं एक हात कव्हर करतो. काय म्हणत होते मी आता? काय म्हणते? नाही काय म्हणतो तो? So, regarding the examination of each witness, we will detailed have a discussion on that subject. The examination of the witnesses, there is also your skill. But skill means, what is the skill? How to record the examination in chief. I am aware, and every defense counsels are aware that the prosecutor is not permitted to add a single word or delete single word from the prosecution case. If it is such condition, do not give interview to media saying that I have done that, I have done it. And that was the investigating officer has, during day and night, he has done the investigation. He is kept aside, and you are giving interview as if you are done the investigation. This interview amounts to contempt of court, because whenever any matter is pending before any court, it is nothing but interference in the administration of justice. Read section 2, definition of the Contempt of Court Act. So do not give such type of interviews for your what do you say. So now I am of the opinion that till now the procedural part, that is the has been completed, and now one thing here remains. after examining the witnesses, if the evidence, the accused is required to be examined under section 313. I am asking you a question now. If it is a case of no evidence, whether accused is to be examined under section 313 or not. If it is case of no evidence, absolutely there is no evidence after examination of all the prosecution witnesses. Now it is stage of the examination of the accused under section 313, and if it is case of no evidence, then whether in that condition, let me know in that condition whether accused is to be examined under section 313 or not. So next time we will discuss the other procedure till the judgment. Thanks.
थँक्यू सर. कोणाचे काही प्रश्न आहेत का? यू मॅ आस्क द क्वेश्चन्स.
एक मला विचारायचं आहे शिवा सर.
यस सर, विचारा.
हा सर. हॅलो.
बोला, तुम्ही बोला, आवाज येतोय.
हा सर, you have stated that we have to explain first 226. Okay. Sir, my question is that there is no provision for preparing or submitting a draft charge. Instead of that, there is a practice of preparing and asking the PP to submit the draft charge. So is it necessary or mandatory for a sessions PP to prepare and submit draft charge?
Now the question is that you are requested to assist the court while framing the charge.
Yes, sir. Yes, sir.
So,
yes,
so if you are giving the draft charge, what is wrong?
No wrong. Okay. Okay,
what is wrong? You are required to assist.
Okay, sir. Okay. Yes, sir.
गजबे मॅडम दिसतायत समोर.
नमस्कार.
Namaste. Your PhD is completed or not?
Sir, awarded PhD in the month of January this year.
काय?
या वर्षी जानेवारी मध्ये PhD award झाले.
So I should say now to her as a doctor. Dr. Leena Gajbee.
It's my honor, sir. Thank you. Thank you, sir. It's my honor. I'll be pleased. आणि आजचं लेक्चर अतिशय सुंदर होतं. म्हणजे बाराखडी शिकल्यासारखं आम्हाला झालं आज. So may I take charge, Chandu?